I'm a little sensitive about where we... Can I walk around? Yeah? Good. So I think we should start. Come in, come in. All right, good afternoon, everyone. Thank you for coming to this session. We're looking at judicial settlement conferencing. You would have seen in the panel discussion this morning about innovations in the judicial system. And this is another innovation of dealing with a case humanely within the legal system. What I want to do is to take you through some basic concepts about a little background for judicial settlement conferencing, then explain what judicial settlement conferencing is really all about, some of the skills utilized by a judge in a settlement conferencing, and just some practical examples of a GSA in motion. You would have heard from Justice Devines this morning about the pilot project, where 100 cases went to judicial settlement conferencing with a 31% success rate. We'll chat about that in a bit. Thanks a lot, Katie. So, just to give you a sort of background, the theme of my presentation is judicial peacemakers, myth or reality. And the whole theme of this whole conference is about making peace through mediation. Is there such a concept of a judge who can make peace? Can the judge assume the role of a mediator or peacemaker within the legal system? We heard about the drug treatment courts, and the judge is shuttling those cases off to counselors, probation workers, and so on. But here it is, the judge is actively being involved in the role of a peacemaker. How is that possible, and how have we done it? So, the focus of a judge in the civil proceeding rules, as we have it, is that the judge is to case manage a case. Right. Was it flying past? Right. And if you're familiar with our rules, the judge must give effect to the overriding objective. And what does the overriding objective simply means? Deal with the case justly. For those of us familiar with what that means in part one, it means that you must deal with the case, what I will call in accordance with the principles of proportionality, equality, and economy. But our credo as judges is trial if necessary, but not necessarily a trial, which is that we will deal with a case with that motto, which is, look, not every case deserves a trial for us to arrive at a just outcome. But if a trial is necessary, so be it. So we are really facilitating the search for solutions to human conflict. And a judge really is now adopting the approach of when a matter comes to a judge in his docket for case management, it is no longer the approach of, well, I'll give you directions and set down a trial. It is now, how can I solve this problem? And then there's a credo of procedural consensus. If it is that the judge is focused on problem solving, he can also focus the attorney's attention in working out technical details in a case consensually. If you, I'll give you an example of how important this is. Right now, there's a case before me which is about 6 years old. Now, 6 years is a long time for a case, especially with a time standard set by the Chief Justice for us to dispose of a case in 18 months. That's the standard for disposing of a civil case in our High Court, from start to finish, 18 months. So why is a case taking 6 years in this example? It is because there are a plethora of procedural appeals, so that the first CMC, there's an application for an amendment of the defense. The judge makes a decision. There's an appeal of that decision. It goes to the Court of Appeal, and it may go to the Privy Council. Then it comes back. I have a simple case of an assault and battery and malicious prosecution between a citizen and some police officers. We made a decision. The state wanted to strike out the claim because the pleadings were insufficient. I made a decision that there's something here that deserves a trial. It went to the Court of Appeal. It went to the Privy Council. And the matter is 3 years in the making. So can we get together to work out aspects of procedure, amendments, changings in case? And this was a procedure I started probably this year with attorneys. For example, simple things like adjourning trials. There's a lot of resistance. Of course, one party is ready, one party is not. I had the unfortunate circumstance of making a decision that this trial, which I've set next week, and you're now making the application for the adjournment today, I'm keeping my date next week. I'm not adjourning it. They went and appealed that. And the hearing of that appeal is next month. So there you go. Right. So that's a practical, so when it happened again, and I said, hold on, I'm not falling for that basket. Let's get together and work out an agreed timetable. So the whole question of agreement and getting parties to agree is not only limited in a judge's work to try to have parties agree on a substantive issue and to work out a substantive solution, but a lot of work has to be spent, in my view, on getting parties to agree on the management of the case. When you look at part 1 of the CPR, and I mentioned the overriding objective, the duty of the attorney is to cooperate with the court to give effect to the overriding objective. And that's a fundamental obligation of the attorney at law. So, and I mentioned the question of a credo of procedural consensus. That language, and I adopted from the Chief Justice of Australia. She made a speech in 2006 where she urged lawyers to agree in the management of cases. So we cut out the procedural appeals and we make the time frame for the disposition shorter. So what's happening what's the global consensus about the role of a judge? And it is, you're now seeing a more active judge. You're not seeing a passive judge. No longer would you see, they used to call the judge a silent sphinx. Now he's an active referee. So it's a new age in civil litigation. The traditional role involving neutral, detached, and passive judges who look to adversaries in private party civil actions has given way to proactive judges who direct disputes towards resolution, increasingly through court-mandated hearings beyond their own courtrooms and judicially managed settlements. Another commentator said that there's a cultural sea change. Courts everywhere now appreciate the positive influences that conflict analysis and management can have on their processes. So this is critical. So you see, we are appreciating what the social scientists have been telling us, that you need to, if our role, as I explained, is to manage the case, there's a substantive element about managing conflict. You're managing the conflict of the parties, the substantive conflict, and you're managing the conflict between the lawyers on technical matters. So there are two levels of hostilities that you have to, yes?
Are we allowed to ask questions?
Well, why not?
But Judge, I mean, could that create potential?
And you were in my court at one time, you were observing some CMCs, so feel free, yes.
Could that result in, for example, attorneys taking technical points that the judge is descending into the arena, is taking over the case?
No one has, excellent point, no one has has mooted this question of the change in the role of a judge under the case management system. And remember, our system is not bifurcated. So what that means is that it is the same judge who is managing the case has to do the trial. In other systems, one judge manages the case, another one does the trial. So this deals with the whole question of descending in the merits. Descending in the merits means they don't want, for the principle of fairness, you want a judge who is impartial. So in a bifurcated system, the case managing judge is free to make his comments and say, well, I don't agree with you with this, why don't you do this, and so on and so on, because he's not doing the trial. We don't have that system, so we have to be very careful. And this is the challenge with case management, and this is the background to the JSCs. The challenge in case management, in being an active referee, is what words and what language we use to manage this case with the credo of procedural consensus. You know that the judge's objective in his mind is to get these parties to agree on procedural matters, to get them to agree on the substantive matter. But I cannot be seen to be making preliminary judgments on a matter without hearing the evidence. So the techniques of the mediator of reframing, asking questions why, these are useful tools now for a judge to get to that whole question of procedural consensus without appearing to descend in the arena, although sometimes we may be doing it, right?
But have you
So,
found that there's taken that point before you have?
not yet, not yet, all right?
I mean, like you, I think.
And that's fine. And I tell people all the time, and you have two schools of thought in managing the case. I'm jumping ahead, but this is important as you raise it. After understanding what a JSC judge does, my thesis is that that judge, using those elements of settlement in a JSC, can use it in the management of a case and talk in a different language. And so when parties come before me, I'm already talking settlement. I'm already talking about, well, why don't you try this option? Why don't you look at this? I don't think these pleadings are kosher. I don't think they're looking right and it's strikeoutable, but why don't we talk about this? And I tell them, I say, but look, we can have a discussion now. If you think that it would be unfair for me to do the trial, let me know and I'll pass it on to someone else. All right, so that's the way I dodge that bullet. Well, no, sometimes literally, right? Yeah, good point. So how is a judge going to generate? I mean, this is more than descending on the arena now. This is not even a mediator. Mediator is not supposed to give options. All right. The JSC judge, it's an evaluative mediation. So there's an evaluative component in it, in that he evaluates the case and sometimes makes some suggestions. That's the style that we've developed. So it is not a mediation. We don't want to even call it an evaluative mediation, but we call it a settlement conferencing. That's where so in case management, I would say, well, okay, first of all, have you all had any discussions? All right, have those discussions borne fruit? Let's take a classic case of damages. I would say, well, how far apart are you all? I don't want to know the numbers. And then they say, well, they're about $5,000 apart. I said, really? So why don't you come down 2,000, you come down 2,000, we're in the middle. So that's one way of generating an option. Without me, I don't know what the figures are, but it's a simple explanation of an option. Another way is like, why don't you all consider doing X or Y or Z? But think about it and walk away and come back and let's talk some more. All right? So Michael Kirby had said that that it's common for judges to take an active part in the conduct of cases that was hitherto conventional. And in part it arises from growing appreciation that a silent judge may sometimes occasion an injustice by failing to reveal opinions which the party then affected has no opportunity to correct or modify. So what will pain me as a judge, because again our access is to deal with cases justly, is that you see a case with poor pleadings, you know where this case is going. There's going to be a loser in this. But let's have the discussion, all right? In many cases, you may have land disputes between families, but the pleadings of the claimant is so poor, it's very likely that it might be struck out, or even if we go to a final trial, the claimant is going to lose. Well, that may be one way of getting the end of the litigation, but it's not really solving the problem between these two families. What it does do, it generates another problem, which is the conflict that arises post-litigation between these families, and then you create another problem between the losing client and the attorney, who the losing client will turn to the attorney and say, well, you've messed up my case, and probably take you to disciplinary committee. I mean, so those are the kind of post-conflict situations that I think we try to avoid when I engage parties in discussions, even in cases that should be struck out. All right? And I think